Welcome to the Semi-Interesting Podcast, where we explore some of the unique legal issues in the global semiconductor industry. My name is Nathaniel Lucek. I'm an IP attorney at the law firm of Hodgson Russ, and one of your hosts.
My name is Elizabeth Morris. I'm an IP attorney and the Director of Intellectual Property and Products at Pure Storage in Santa Clara, California, and I am one of your hosts.
It will not surprise anyone listening that American intellectual property litigation and other complex commercial litigation can be extremely expensive. Litigation funding, or financing by third parties, has been described as a potential fix that levels this playing field. No longer do small plaintiffs need to worry about how to pay for protracted litigation against a larger defendant, and defendants potentially need to take these claims from plaintiffs more seriously. But where does the money come from? And what does third-party funding affect during a litigation? Our guest today is Justin Maleson, who is a director at Longford Capital. He offered to give us a crash course on litigation funding. Justin, I appreciate you joining us today. Could you please give us a short introduction to Longford Capital and also to yourself and what you do there?
Nathaniel, Elizabeth, thanks for having me. I think it's going to be fun. So, Nathaniel, as you mentioned, I am a director at Longford Capital. Longford was one of the first litigation funding companies in the United States, and we are one of the largest funders in the world in terms of assets under management. So I joined about 6 years ago. Before that, I was a litigation partner at Jenner & Block. I was very much a generalist, jack of all trades. I know that can be a bit of a dirty word in today's world, but I wear it as a badge of honor. I think it's a good thing. And then it served me really well to be a generalist, litigating anything and everything. So that is me in a nutshell.
Justin, it's so nice to meet you. I have one question before I actually jumped into my real first question, which is, if you guys were one of the first and you joined 6 years ago, is that kind of when things got started? I feel like I didn't start hearing about litigation funding until maybe about 3 years ago. So I assume it's been kind of gaining traction over time. But I mean, how did you get involved?
That's a really, really good question. So the company launched in 2011 and the first fund in 2013. And I want to say we were one of the first 2 or 3 in the country. Funding has been around, though, in Australia, in the UK. So it has been around in other parts of the world and just recently transplanted over to the United States. Although your instincts are right. So I joined in 2018. But even since 2018, the growth of the industry has been astronomical. I mean, when I would talk to people in 2018, there was a better than 50, 60, 70% chance that people had no idea what I was talking about. They had no idea what funding was. And now, for the most part, everyone has heard of funding. Everyone's familiar with funding at various levels, right? But folks have mostly heard of funding. So I think you're right. It's been really the last, maybe since COVID, things really got became a larger part of the public consciousness in the legal field. So it's continuing to grow and it's becoming just an accepted part of the litigation landscape at this point.
So definitely I've seen an interest in that litigation financing spiking, probably from both parties, right? So where do these investors come from? Who are you talking to?
That's a good question. So the investors, it depends on the fund. Different funds sort of raise capital differently. For us, we're mostly institutional investors, think university endowments, pension funds. The other part of sort of our investor base, think high net worth individuals and family offices. That's where, the vast majority, potentially all of our capital comes from. Again, other funds have different investor bases, but with us, we're very largely institutional.
Not assuming, you are funded. How does a potential plaintiff then find you in order to get access to some of that funding? And what do they bring you? What do they have to show you in order to get your attention?
It's largely like, with lawyers, relationship driven, referral driven. So much of it is sort of network based. I think, and it's gotten better, but I think because funding, a lot of people don't have the sort of intimate familiarity with it. With most new things, I think there's often sort of a trust barrier. And so for me, my experience has been that having those personal relationships, right, either coming through referral or just spending time talking to people and sort of building those personal connections, that's really what drives my pipeline. And a lot of my work is, at this point, it's been 6 years now. So a lot of my work is really repeat, folks that I've worked with before, not only funded, but folks that have brought me cases before that I've declined. That's shockingly a huge part of the business I do is from folks that I said no to before. I'd like to think it's because because we reject so many cases, try to handle every situation to add value along the way. Because again, you're going to be saying no, 90+% of the time, you need to add something as part of the process. So again, it's largely network driven. Sometimes it's the lawyer that has the client. Sometimes the client will come right to me. We're not out there cold calling. We're not out there, sort of trolling the internet for cases. That's just not our approach. And so again, network and relationships.
So when they do find you, or when they have that relationship, they're bringing you a draft complaint. They're bringing you, if it's a patent infringement case, I assume they'd be bringing you a claim chart with, here's what we think, here's the infringing product. What's the package look like?
Yeah, that's a good point. So budget is a big piece of it, obviously, because we do a lot of financial modeling. Depending on where the case is in sort of the life cycle, because we'll invest in cases pre-filing, we'll also invest in cases midstream, we'll invest in cases post-judgment when they're on appeal. So we really do at all stages. But the typical packet in a pre-discovery or a pre-litigation early discovery case, it's going to be the complaint. It's going to be, are there any key orders, right? Not the pro hocs, but what are kind of the key orders, key rulings the court has issued to that point? It's going to be the claim charts. That's obviously a very important piece of this. And then a damages analysis. The damages analysis does not have to be done by an expert. Eventually, obviously, that will be part of it. But for that initial packet, at least a lawyer workup of what the potential damages look like, that would be, I would say, the core packet of information we're looking for to start the diligence process. And I should add that the diligence process is meant to be iterative. So the more we're sort of given up front, the more it will expedite the timeline, but it's very iterative. Once I get my hands in the documents, dig in, I'm naturally going to have questions. I'm going to want to see, this or that. But being able to kind of dig into the core materials helps sort of guide, okay, what is it that I need to see? What is it that I want to see to answer X, Y, and Z questions? And so we really like to have kind of that core base to then figure out where to go with the questions to be as efficient as possible.
So if you're rejecting like 90% of the things that get sent to you, what are you looking for in a good case? And I think specifically, Nathaniel and I are both, IP attorneys. So we're especially, of course, interested in IP infringement. What makes an interesting one to your organization? What's one you would want to take on?
So with I'll focus on patent cases. Obviously, that's the primary audience here, I believe. Multi-patent, multi-defendant. So those are sort of two core principles. Obviously, there's a lot of variability in the IP law across the country. I do a lot of commercial cases as well. And with what I tell people is with the commercial case, if a case is going to lose, I can tell you the 3 or 4 ways it's going to lose, and I can sort of bake the risk profile in there. With an IP case, I often joke with my colleagues where that's all they do is IP cases. There's about 10,000 ways to lose an IP case, and the path to winning is a lot more narrow. And so with that, obviously for being a funder and taking an independent view on whether we think the case is going to win and how profitable, when you can add more patents, it helps to mitigate the risk. More defendants gives you more potential places to recover. And then multi-jurisdictional, not always necessary, but often helps because certain jurisdictions obviously have different rules on issuing injunctions, and that can be a really, really helpful lever when clients are negotiating settlements. So we like to have sort of different paths and different ways to help mitigate the risk. But I should say merits are king at the end of the day, and there are good patents, there are bad patents, and there's obviously some subjectivity in it, but the strength of the patents is going to be first and foremost when we're evaluating cases.
So really, like, how strong are these charts? How well do they really read on the potential defendants?
Exactly. And we don't always do this, but depending on some firms, when they bring us a case, will also have done a prior art search, right? Which is obviously a huge help because it's something that's going to need to be done one way or the other. That can be done at different stages of the process. But again, the more that's sort of in the package up front, it just helps expedite the timeline. Not that we can't still do the diligence, but from a timing perspective, the more that's done up front, the easier it is.
Assuming you are interested in the case, let's talk about the mechanics of your motivation here, which is money. How is it that Longford Capital then profits on this? Is it you're looking for cases that the plaintiff's going to win? That obviously would be preferred, but what happens if the plaintiff loses? What happens if they take a detour and decide to do a license agreement or a settlement agreement along the way? There's lots of ways that it can end. So how is it that you bring returns back to your investors?
So the first and most important thing is we only do non-recourse investments. And what I mean by that is we're not loaning people money. We are taking the risk that there will be a recovery. And if the case loses, there's no recovery, that loss is on us. That's the risk we're taking, is that the case isn't going to prevail. In terms of how we recover, licensing, litigation, settlement, right? It can be any of those recovery streams. Licensing revenue is treated the same as settlement revenue or revenue from a judgment, whatever it may be. And so we factor all that in, and we're looking at all of those things when we're looking at a case up front, because yes, we obviously have cases that go to trial and go to judgment. But I will tell you, if we think a case is probably going to trial, more likely to go to trial, that's a strike against it, right? Because what we're looking for is we're looking for cases we think where there is a likelihood of there being a settlement, right? And settlement is driven by the strength of the claims, and it's driven by the value of the patents. And obviously there's a lot of different factors that go into it. But as a funder, we're often looking for, okay, which cases profile to be the type that are going to settle, because there's certainty in that you don't get in a trial scenario. I can't tell you how often, both in my prior life at Jenner and here, you think this case, there's no way this case can lose at trial, and then it happens. And then the converse also happens, like, well, this case, and then here's $100 million verdict. So when you put a case in front of a jury, you just don't know what's going to happen, as good as you feel about it, frankly. And so we're often looking for what are the different ways this particular investment could return capital. And I think this is an important point that folks often don't think about with litigation funding, understandably, because it's litigation funding. But a lot of our funding actually goes towards licensing campaigns. You don't need to sort of litigate, it's not always about suing people. And I think that's not always known. And I think it's valuable because here's how I think about it. There are two, call them branches of funding. There's the more traditional branch, which is we, Longford, we pay, law firm a portion of your fees. We pay your experts, all the out-of-pocket. So Longford is paying on behalf of a client to lawyers, to experts, out-of-pockets. That's the traditional, what people think about with funding. Then there's the monetization branch of funding. And what that is money being paid directly to the client. And so sometimes that takes the form of a lump sum payment up front. Sometimes it takes the form of ongoing OpEx to help the company. We often do a lot of work with startups where OpEx is tremendously valuable to them. And so we're able to pay some of the OpEx. And that money is non-recourse. And it can be used for whatever they want to use it for. And there's no obligation to pay us back unless there is a recovery. And so we often are looking at funding opportunities where there's not always litigation involved. Sometimes, because of the speed in the semiconductor industry, as I understand it, because of the speed, right, licensing is often a big way to generate revenue, and having, the patents, getting the patents quickly and being able to get them licensed rather quickly, it can be expensive, especially when you want to make sure you have the best people that are writing the patents. And then once you have them that can show the value to the potential licensee, right? They have to be able to show the value to the licensee to get top dollar for the patents, for the licenses. So we actually do fairly often licensing campaigns where, yes, like the threat of litigation is there if need be, but they're often designed to help drive licensing revenue. So that's another way we use our capital to help with licensing efforts.
So if you're dealing with sometimes startups, for instance, or other, small organizations that are looking for kind of this OpEx monetization idea, they're new, they don't have that many patents. Are you helping them create patents that could be used, or are you only looking for organizations that already have a good, valuable patent in hand?
Both. So sometimes companies either have the patents and then we can help with the licensing campaign. But we have funded patent prosecution work. There's, as you folks know, you're as good as it gets. And so, but there's a difference between Nathaniel, your firm, right, and the firm that the one-man solo who just hung up the shingle last week. Again, it's a broad generalization, but there's a difference in quality. And so sometimes, startups, for example, they don't have the money to allocate to these types of legal expenses, right? They want to keep their capital for the core business. And so they often end up having to cut corners, unfortunately. And if the patent isn't written well, then the patent is worthless, unfortunately. And so what we often are able to do is to come in and provide funding to give the clients more choices, right? Go out and find the best lawyer to help prosecute the patent, to draft the patent, and we absolutely provide funding for that as well.
So then you're just looking for a really good idea. I mean, how would they prove? I'm just thinking, living in Silicon Valley, I have lots of friends who are in startups, right? Like if they wanted to hook up with you to get some money, like because maybe they are in the situation where they're hiring small firms and trying to cut corners, like how do they get to the point where they could prove that they're valuable enough that, Longford would be interested in investing?
We would lean on the lawyers. So we'd lean on, you to help us do that workup. If it's someone you're familiar with, Elizabeth, right? Someone we lean on you to kind of help put that together. There's also a lot of firms out there that will do that work as a freebie sort of favor. And if this ends up going somewhere, they will end up litigating it. So we know lots of shops that would do that. And for example, if there was a client that had a great idea that needed a recommendation for a firm to look at it and help work it up and see if something was there and it was worth putting the patent together, could absolutely make those sorts of introductions. But we would need a lawyer to help do the workup to sort of display and show the value. But we've done that before.
So then just switching gears a little bit, kind of understand how small companies with limited resources would make sense. Do large companies ever come to you? And if they do, why? What are they looking to gain?
They do. And that is surprising to a lot of folks. A couple reasons. So one of them is there can be accounting benefits. So for example, we were talking about monetizations earlier. If you litigate a case and you get a big judgment at the end of the day and collect your big judgment, when that comes back to the books under GAAP, it's treated as a one-time extraordinary event. It has no impact on the value of the company. What we do is if we do a monetization, we'll often structure them as sort of a quarterly payment or a semi-annual payment for X number of years. And so that becomes a revenue stream that automatically hits the bottom line of the company and boosts the book value of the company. So that's one, is there are accounting benefits to what we're doing. Another is it's risk transfer, right? So a lot of times the companies are sort of paying out of their own pocket. There's other ways they'd rather kind of spend the money. They can transfer some of the risk to us, keep some of the upside. So sort of general risk transfer concepts. And then budgeting is another one, right? A lot of times legal departments have their budgets that they're stuck to, and those budgets are often, maybe they're spent on defense costs primarily. They don't have additional budgets to go out and pursue plaintiff side cases. And for companies that don't do a lot of plaintiff side litigation, right? Maybe they have one every year or two. It's just not something that they're very familiar with. And they don't often have, the contingency lawyer to pick up the phone and call and say, I have this great plaintiff's case. Would you look at it? And so what we'll often do is we can help with budgeting where, okay, we can come in and help pay for this. It makes sure that your budget remains steady. It's off budget, but you help turn the legal department from cost center to revenue generator. And so it's one of the ways where the outlay from the company, you can actually potentially bring capital in for the company. So those are the primary reasons we'll see big companies doing this.
I have one quick follow-up on that. So you were just saying, companies might come to you if they aren't doing a lot of plaintiff side. Do you ever work on the defense side of things, or are you pretty focused on the plaintiff side?
Yes, we actually do some work on the defense side. And I'll give you a couple examples, but in the pharma space, think about the pharma space. So very often you will have a generic who wants to bring their drug to market, and the brand will sue them and say, no, they'll seek an injunction. You can't bring your drug to market. You're infringing. And so what we have done in other situations is we will say, okay, we will pay your defense costs here, for example. If you win, then you get access to the market. And that market access serves as almost a proxy for, because you're not collecting damages like in a typical case, but you can use the revenue generated from access to market as a stand-in for the proceeds that you would recover in a lawsuit. So that's one way that defense funding is happening. I will tell you that's sort of plaintiff's funding in defense shoes, but it's still nevertheless something that's done. We're also working on and have a operational defense model that is pretty new and pretty unique. It's not something that we've deployed anywhere near to the extent we deploy the plaintiff's model because it's more complicated. But defense funding, and it's sort of the holy grail for funders, defense funding, I think, is something that funders have continued to try to crack the nut. And I do frankly think there are paths, and I do believe we're going to see more and more of that in the coming years.
So assuming you have a good case, you have an attorney or a firm that you've worked with or you trust, having you on board as a funder, what does that do for who's directing how the litigation is going to go? I mean, are you sitting in as co-pilot, or are you just in the back hanging out?
No, I'll be very clear on this. We do not have any seat at the table. We do not control litigation. One, it's prohibited. Two, no lawyer wants another lawyer looking over their shoulder. And so this is the reason why we spend so much time in our diligence process up front, because that is when our decision gets made. And when we're looking at it, it's not only we're looking at what's the state of sort of the case today, we have to think about, okay, in 2 years, when there's inevitably twists and turns and things have changed, right, we need to make sure that, we want to make sure expectations are aligned, right? That's maybe a good way to say it. There have been cases where I really, really like the case, but there's sort of a misalignment in terms of the way I view the case and what I think the value of the case is and what the claim owner sees the value of the case is or what the lawyer is. And that's completely fine. Those are situations where I won't invest because we just sort of have a mismatched set of expectations. And because we're trusting the lawyer, we're trusting the claim owner with our capital, and we're passive investors, it's important to understand sort of what everyone's expectations are, to make sure we're all thinking about it the same way. Because again, there will inevitably be things in every litigation that are unexpected, and just having the confidence and the comfort in knowing, okay, I trust your decision making, that's a key piece of it. Because if without that trust, without that sort of relationship, it's really hard to say, here, be the steward of my capital when I'm the steward of someone else's capital. And so having that trust and having those relationships, it's really, really important with what we do.
Do you have certain law firms that you prefer? Or I guess when clients come to you, like a company or maybe a startup or whatever, and it's looks like it's actually going to go to litigation, not just to be a licensing campaign, are there law firms that you suggest or strongly suggest, or is that really a decision that the client gets to make?
That's a client's decision. I'm sometimes asked for recommendations. And if someone asks me, I'm glad to give, here's several recommendations for firms, depending on the technology or depending on the kind of case, right? I mean, one of the benefits of sitting where I sit is I do spend a lot of time talking to lawyers and have a pretty good feel for what firms or what lawyers are going to be better at different things. And so if I'm ever asked for a recommendation, I'll willingly provide a few recommendations. But for the most part, most of our cases are coming to us where lawyers are already involved, or the client has at least talked to lawyers. And so that is such an important part of this, is there really has to be trust all around. And the last thing I would frankly ever want to do is make a recommendation for a client and the client ended up being very unhappy. And that's just bad for everyone involved. And so that's entirely a client decision. Again, I'll give recommendations, but it's not something that we have any sort of active role in deciding.
So typically people are coming to you, they already have their lawyers, because I guess in IP cases, there's already a chart, that which has to be sort of essentially made by an IP lawyer or someone that's very familiar with IP law anyways. Then how do the attorneys maintain their duties of confidentiality when you need some information to decide if you're going to back it?
So this is actually cleaner than I think a lot of people think. So the body of law that's developed around this is very robust. And so principle one is put an NDA in place on day one before you share any information. So that's always step one. Two is never, ever share information that is protected only by the attorney-client privilege. I don't want it. I don't want privileged information. Don't give it to me. There's no benefit to it. There are a few exceptions out there that some courts have looked at and sort of common interest, but I will tell you, I don't think it's a very strong argument. I wouldn't want to have to argue sort of common benefit, common interest. And so the answer is don't give me any information that's only protected by the attorney-client privilege. But the law is robust and clear that work product shared under a valid NDA, it's protected. And courts across the country have regularly upheld this. And so the law is very consistent on this. You'll get an outlier from here and there, depending on sort of unique circumstances. But when disclosure is required by a court, it's typically pretty limited because the information is not relevant to the claims. And so when courts are looking at this question, to the extent they are requiring some disclosure, it's often in camera, or it's often a redacted version of the funding agreement. It's very sort of narrow in scope for the most part. And again, which is why I tell people, I don't want your privileged information. I don't need your privileged information. It can only harm the case by giving me your privileged information. The other thing that's important is protective orders. If a protective order prevents you from providing information to me, don't give it to me. I'm a big believer in taking the most cautious approach. And if you're even close to the line, I don't want to see it. So we try to be very cautious. I think it's the right way to do things. And it is a rare situation where I can't conduct the diligence I need within those lines. And if I can't conduct them within those lines, I respectfully decline the case.
Since you mentioned disclosure, let's talk about that on the other side of the litigation, which is, does the plaintiff or the defendant need to alert anyone that you're involved? Can they keep your presence a secret? What are the rules around that?
That depends on the specific court you're filing in. So international arbitration is another example. I do a lot of international arbitration. In those situations, disclosure is pretty commonplace. And almost all the major tribunals, the major arbitration companies, they have required rules on disclosure, which makes sense because they're worried about conflicts with the arbitrators that aren't judges, right? In the litigation sense, I would say that by and large, disclosure is not required, but there are courts that do require it, sometimes by standing order, sometimes by, local rule. There's currently no federal rule of civil procedure that would require it, but it's a court by court type situation. I will say from our standpoint, at least the way I like to think about it, as a company, we're not opposed to disclosure. It's not our call though. It's a client call. It's a lawyer call. And we sort of think about it as if a third party with a good reputation is willing to invest millions of dollars in your case, I believe that's a good signal to the other side that, okay, maybe there's some validity here, there's something good here. So we're not anti-disclosure in any way, shape, or form. The challenges happen in the disclosure world where things can kind of go off the rails and become a sideshow, and that ends up costing everyone money. It ends up diverting from the actual merits of the case. That, I think, is sort of where the challenges come in. But in general, disclosure for disclosure's sake, as long as it's done in a properly tailored way, I don't think there should be any issue with it.
You were saying earlier you kind of have these two branches, I guess, right? The traditional kind of funding of the things that happen in litigation, and then the monetization thing, and that you are often funding licensing campaigns. How does it potentially switch? Like, let's say you're funding some organization that has a good kind of licensing program, and then they hit some potential licensees who need to be sued in order to be encouraged to license. How does that affect things?
It's a good question. So when we're putting together a term sheet or a funding agreement, it's often set up in sort of phases or blocks, right? And so there will be as part of the overall budget, there's often a budget for the licensing campaign, but we'll often also allocate capital in the event of what you're saying, because that's obviously something that could happen, that we recognize the possibility that litigation could ensue. So we'll often block off capital to address potential litigation as well. So we try to set those things up front in terms of the reasonably foreseeable paths things could go. And obviously things can change, but we do try to sort of forecast and predict the way things could go and to set up the budget appropriately so that there's enough capital there for everyone to proceed as needed and then kind of play it by ear.
Thank you for the introduction or explanation on some of the multitude of scenarios that litigation funding can be laid out and used. Some of it was new to me, and I appreciate you taking the time to explain how it all works and removing some of the misconceptions that people have in terms of what litigation funding is and how it is commonly used in a U.S. court.
Yeah, I learned a lot.
Thank you both for having me. This was a lot of fun.
Thanks so much for listening to this episode of the Semi-Interesting Podcast. You can find more episodes wherever you get your podcasts, including YouTube.
And if you enjoyed the episode, we always appreciate 5-star reviews. While we talked about legal issues, none of the information shared during this podcast is intended to be legal advice. If you have any questions about information we cover or ideas for a future episode, feel free to contact me or the other attorneys at Hodgson Russ. You can find contact information at www.hodgsonruss.com.